We discuss 10 questions, around 10 questions regarding Article 143 in this video. The first question is, what is the scope of Article 143? Otherwise, which type of question of law can be referred to the Supreme Court by the Supreme President of India? So now come to the question of law. Uh, which type of question of law? It should be of a public importance in the opinion of the President. It is up to the President which type of questions has to be framed. So, according to Article 143, it should be of public importance. The other thing is either law or on fact. All these things are there in Article 143 itself. So, whether it relates to functions and duties of the President or not. So, these are the some parameters given in reference under reference of year 1965 and 75. Come to other parameters. So the question of law is already arisen or is likely to issue. So there is no limit. It is not necessary to the president to wait up to has arisen of the question of law. Even at the interior stage, likely to arise. If President satisfies that the issue may likely to arise, then the question of law can be referred to the Supreme Court. That is the other important aspect which has been held in Kaveri Tribunal Water case is that 1991, if Supreme Court already adjudicated on question of law, President cannot have any doubt on that. So the President can refer a question of law which the Supreme Court has not decided at. So such type of question of law only can be referred by the Supreme President of India. So because these decisions, adjudications done by Supreme Court are binding on all the branches of the government or constitution. So it becomes res judicata. If again it is referred under Article 143, it becomes res judicata, and at the same time or otherwise it becomes an appellate jurisdiction. Supreme Court has been forced to sit as an appellate court. We know that there are no appeals against its own order in the Supreme Court. So the only remedy is Article 137. If there is any gross error, principles are like a principle violation of principles of natural justice, or any per inquirium judgment, in such cases it can be revisit under Article 137 by utilizing inherent powers of the Supreme Court, not by appellate powers. So Supreme President cannot act as an appellate power. So executive has no power to ask the Supreme Court to revisit its decision. That's why President can refer only the question of law which has not been decided yet. The other thing is Article 143 is not dealing with the jurisdiction of the Supreme Court. It is power of the President. What does that mean? We are giving advisory jurisdiction, the heading for this Article 143. But it is, in the real sense, the President has power to refer some matters to the Supreme Court. So we can see it as an power of the President, because there is no adjudication, there is no contesting between the parties. So it cannot be termed as the adjudication done by the Supreme Court under Article 143 cannot be termed as a decree or judgment or like. It is only opinion. So This is the uh, power of the president, not jurisdiction of the Supreme Court. Supreme Court is free to re-examine or review its own view, which has been taken in the form of opinion under Article 143. It is not final. Final means to that extent is final, but if necessary arise, and then Supreme Court is free to re-examine or review its own view taken in the form of opinion under Article 143. Whether the opinion given under Article 143 is in binding nature, for that, the Supreme Court in two cases clarified that the Ahmedabad Saint Xavier College Society and another versus State of Gujarat, and in another case also clarified that it is not binding because it is not rendered a judgment. Supreme Court never rendered a judgment in this case on contesting. It is only opinion, but it is having some weight and persuasive value before all the courts. So, despite there is a different opinion by earlier Chief Justice Chandrachud, not D.Y. Chandrachud, his father, there is a difference of opinion. But the broadly, it is not a binding precedent, but it is having persuasive value and it is a weight and in all value in all courts. Regarding the question, can Supreme Court decline to answer the reference given by the referred by the President of India? Yes, it can be done. In the reference one of 1964 itself, it was held. Supreme Court held in that same way. We can refuse it to do also, but first time exercised in 1993 that Ayodhya Babri Masjid case. So, Supreme Court, while declined to give answer, has made serious comments also, like the subject matter of the reference favored one religious community, not favored another religious community. So it is against the secularism, constitution, held unconstitutional. Even the central government is not intended to settle the dispute basing on this 143 reference. It may be used it as a springboard to the negotiations. So Supreme Court declined to give answer. No cross examination, no contesting, no difference of opinions. Sent to the Supreme Court. So Supreme Court held that we can't give our opinion. Not only that, in 2G reference case, Supreme Court has given certain types of category. When it is improper, inadvisable, and undesirable, or the questions formulated have purely socio-economic or political reasons which have no relation whatsoever with any of the provisions of the Constitution, otherwise are of no constitutional significance, or are incapable of being answered, or would not subserve any purpose, or there is authoritative pronouncement of this court which has already decided the question referred. So already referred are inadvisable, are improper, undesirable, purely so like this. Some categories have been given in 1979 reference also certain categories incapable of being answered. Supreme Court also may be incapable of certain things. So hypothetical and speculative, superfluous issues. These are the some categories of the judgments that can be declined to give answer to the reference. And then what is the procedure? And according to Supreme Court rules 2013 part 42, order 42, first after receiving the reference, the registrar will give notice to the Attorney General of India. Thereafter, the parties as may be desired, such parties as may be desirable. So, who are the parties may be decided by the Supreme Court. After serving the notice, hearing. Hearing based on the procedure adopted in the original jurisdiction. So, we know that original jurisdictions, Article 131 and other things. So, like that, hearings will be completed. Thereafter, registrar shall transmit the report of the court to the President of India. So, these are the procedure. Can Supreme Court pass interim order during the pendency of the reference under Article 143? Yes. In special reference 1993, that is regarding Babri Masjid case, the Supreme Court uh, passed some interim direction regarding preservation of the objects. So, not the testing for age and other things, passed some interim order. So, it can be done. Can previous judgments be explained, clarified, or modified under Article 143? For this, we have to see the reference of 2G spectrum 1 of 2012. Basing on previous two references, that is Keshav Singh judgment and judgments, second judge's case, the Supreme Court clarified in 2G spectrum case that it can clarified or modified. You see, in Keshav Singh case, under Article 143 reference, Supreme Court clarified that MSM Sharma versus Sri Krishna Sinha case regarding a proposition laid down in another judgment was inaccurate. So it clarified that certain judgment is proposition is inaccurate. In second judge's case, Supreme Court clarified and the dictum given in Supreme Court Advocate on Record Association judgment. So like this, in 2G spectrum course, Supreme Court has given clarification, but it should not, what do you call, touch the original ratio laid down by the earlier judgment. As long as it is not touched, it can modify, it can clarify. That is the. So some of the landmark judgments basing on Article 143 are that 1993 Ayodhya judgment reported as Ismail Faruqi case and Kaveri Water Tribunal case. Very important judgment. Some principles are laid down. And 2G spectrum reference case and 79 case. So there are some other judgments, but these are the important references, important landmark judgments given under Article 143.